Everything for high juicy news. Mema Obibia Kwaba. I had the latest hot and Aremeyaw Bremo. And so we subscribe to channel area. Bomodian say obe subscribe. Robeyan say obe click a year the subscribe button. Now barely notification. We understand video for free be upload with the first person once ebeka. Yes, video. Afi we are now like video no. Give us a thumbs up. Na fi share ma wo fufuro so na when you be here. Na ensem dodo na ra ekoso ewo Ghana memo hano afi yemura ye ensem a abeto yepono so yinti eye report ya ababeto je sankomo yimuma yinti.
I have cautioned and suggested that she should take a back seat. Government should take a back seat. They should allow people who are less emotionally touched as far as this matter is concerned, so that we will bring it to an end. It may either fail or it may succeed. By bringing this action, she has closed the door. Now, before, the door had been slammed, but the key was left hanging absent, so that one day she could go and take the key, unlock, and then enter. But what she has done now, even if the petition fails, I don't think that she can ever work with the executive again. It's a wrong move.
Yes,
now, as far as the injunction is concerned, I can predict that it's doomed to failure, because such an injunction may be the Chief Justice may be required to address the court on specific points of law and fact on the basis of the papers she has filed. What is she going to allege? It is the same response, to the president based on the petitions the president forwarded to her. Therefore, what he's trying to do is, yes, I have responded, but no, I will not allow you to go into that. The wrong signal to the nation is that she has something to hide. When to all intents and purposes, she may have a good case. But it's like she's drowning and she's trying to, clutch onto any straw that may come her way. That's not how, to litigate such, sensational and sensitive, matters of national importance and interest. I think that whoever advised her to do that, has still advised her. I wouldn't advise her to do that. And, it's a wrong move.
But it's well within her right to do what she has just done. I mean, you described it as a wrong move. She wants to pursue this matter in the court.
She's the chief protagonist, and therefore, she must not be drawn into what people who are less knowledgeable about the law will do. She is the chief priest or priestess of the judiciary. That's how come she's the Chief Justice, the head of the judiciary. She's trying to stop a constitutional process. That in itself, is a base to impeach her. That in itself, because she is seeking, to act contrary to the dictates of the Constitution. I mean, it's a wrong move. It's a wrong tactical move.
No, sorry. Appreciate your time on this, and we'll see how this will play out, especially because Dennis, my colleague, references that some of the relief she's seeking are contained in a previous injunction filed by Vincent Assefuah, of which the full details of the ruling will be out by close of day today. Would you also go on that same path that one of the justices was seeking to sort of advise the lawyers of the Chief Justice that to wait for the full ruling of the previous injunction that was thrown out on this similar relief to be out today to guide them on what next step to take instead of filing the injunction earlier today?
Well, it's a constitutional right to act, within the dictates of her own judicial conscience, and person. I mean, she may decide to go, the right way or the wrong way. But interestingly, if I heard you, right, you did mention the fact that she's seeking, she's seeking the removal of 2 justices, on the panel. That's Puama and Ekidu. That's another dimension. But whatever it is, it's a right. I'm saying that, just as a judge, they may decide to, go right or wrong. So a litigant may also choose, to go right or wrong. But the head of the judiciary, being the architect of the, judicial architecture, must be the last person, to sue the president. I mean, if you sue the chief justice, the attorney general, you have sued the president. The fact is that the president may not be sued, within the period that the president, is the chief executive of the state, and therefore the person you can sue is the attorney general. If you want to sue the state, you are suing the executive, you are suing the judiciary, you are suing the legislature, and it is the attorney general, who will have, to defend, howsoever she chooses and whatever way she chooses, to run this saga. It is the attorney general she must sue. Now, if she wins, let us, say that for purposes of argument, she wins. How is she going to, repair the harm as far as the relationship of the office of the Chief Justice and the office of the President is concerned? How is she going to repair the harm? It's irreparable. And this is why I'm saying that whoever advised her, to comment this action has done more harm to her than good.
For one majority decision, the Supreme Court has dismissed another injunction application seeking to halt the ongoing removal of processes for Chief Justice Gertrude Torkonoo. The court, presided over by Acting Chief Justice Paul Bafoboni, ruled that the application filed by the Center for Citizenship, Constitutional and Electoral Systems lacked merit. Justice Bafoboni, Isifu Moro, Tanko Amadu, Emmanuel Yoni Kolendi, and Henry Anthony Kofi formed the majority, and while Justice Yaudakon Asare dissented. Now, this marks the second time the Apex Court has rejected an injunction application to stop the impeachment process. Now, the first, if you recall, was filed by Vincent Ekosofo, the Member of Parliament for the Otafu constituency. Now, this particular civil society organization had argued in its writ that the handling of the Chief Justice's impeachment process violated due process and several constitutional provisions. The group sought to suspend the work of the 5-member committee investigating the petitions against the Chief Justice until the final determination of the substantive case. Well, Lord Edwasare is a legal affairs correspondent. He was in court earlier today for us. And Lord, you witnessed the entire proceedings today. How did all the issues unfold in court?
Good to be here, Alfred. Now, quick updates. The cases before the court today were actually 2, right? So the previous one, the first one was by the civil society group, and then the second was by private citizen Theodore Kofi Atta Korte. Now, the Apex Court heard that of the civil society first. Now, their issue or their case was that in determining the prima facie against Chief Justice Gertrude Torkonoo, the president did not hand over that document to her before passing down or issuing that warrant of suspension, which has now determined her status as we speak, Alfred. And so the lawyer led by Jacob Aqua argue that that was an irregularity or unconstitutional. Now, their substantive case had to do with the interpretation of Article 1468, which has to do with the entire proceedings being in camera. Now, one of the documents that they attached to their affidavit in support was that some of the allegations and petitions which, Alfred, we both know and have seen that they have been in circulation on social media, right? Now, the lawyer indicated that the case which should have been in camera, the document was flying all over social media, and he sought the court, or he prayed the court to injunct the entire processes, i.e. to stop the committee from sitting, and then also to order the suspension of that warrant which suspended the Chief Justice essentially. But at that point, the Deputy Attorney General, Dr. Justice Stremtai, he opposed the injunction, indicating that the allegations that the lawyer for the civil society group was making was simply frivolous, and that some of the documents that he had attached were, to speak, classified information. So he didn't, that shouldn't be something that he can attach to his case. At which point he indicated that, well, he didn't just come by them, it's in the open for everybody to see. It's on social media. At that point, one of the justices on the bench, Justice Amadou Tanko, he prodded further, asked him that is he sure that this document that he's claiming is classified is the actual document from the committee sittings, because a number of them itemized or outlined the allegations against the Chief Justice Gertrude Torkonoo. He couldn't confirm same, but by and large, after the arguments, the judge, the bench, which was made up of the acting Chief Justice Bafuboni presiding in a majority decision, dismissed the application and held that it was without merits. The other judges who were on the bench were Justice Anthony Kofi, Justice Yasar Dakon was the one who dissented. It was a 4-1 decision, right? Yes. And then there was also Justice Amadou Tanko. So, and then Justice Emmanuel Yonukulendi. Now, to the second case, right? Once there was a brief recess, and then the second case was called. Mm-hmm. Now, the second case has to do with the private citizen Theodore Kofi Atta Korte. Now, his case was that even before I come to Kofi Atta's case, that's quite an interesting situation with the first case, right? Now, with the suit of the civil society, the defendants were the Chief Justice, the suspended Chief Justice, Gertrude Torkonoo, the Attorney General, and then Justice Pomang, who is the chairperson of the committee, right? Now, the lawyer for the suspended Chief Justice, led by Kwabena Agyapong, he argued that there was no prima facie determination in the first place. Now, he made the argument that if there was any prima facie determination to begin with, it should have been provided or made available to Justice Gertrude Torkonoo. He indicated that there were 3 offered petitions against the Chief Justice, right? The ones that were being considered before the December prima facie. And those 3 petitions were made up of several different allegations. Now, in his argument, Kusiadu indicated that the president, in issuing that directive that the prima facie had been determined, did not outline which of these petitions that they have found a prima facie. Again, he didn't state the allegations which had been found to be culpable. The Chief Justice was found to be culpable, and that was why the prima facie had been determined. And with all this, he indicated that can be the case and say that there's a prima facie. So he was questioning the whole motive of it. Now to the second case that had Korte. He was of the view that as far as the committee was concerned, per the provision of the Constitution, the members or the actors who took a look at that petition were non-judicial actors. And there should have been a constitutional instrument, because the president is not a judicial actor. And so there should have been a constitutional instrument which guided his decision leading to that determination of prima facie. So this was the crux of everything that happened in court today.
So essentially, the Supreme Court has dismissed this other suit against the processes, against the removal of the Chief Justice. essentially because they were unmeritorious.
That was the baseline of it. They found it to be unmeritorious, and so what it means is that the committee are still going to go ahead with the impeachment processes, and because we already know, Alfred, that they are sitting 3 times a week, Monday, Wednesdays, and Fridays, and so they are still going to continue with that sitting. They also indicated that the full reasoning of the court will be made available on May 29.
Well, there is another development that happened in court, a very big one. So stay with us here on Hot Edition. We're going to break that news to you shortly. Let's bring in Martin Pebble. He's private legal practitioner and then also the leader of the Commitee, the demonstrations. Join us on the telephone right now. Counsel, good evening. Thank you so much for joining us here on Hot Edition. Hello, Counsel, good evening.
Yes, evening.
Yes, I appreciate your time. Having had the Supreme Court ruling a 4-1 majority decision dismissing this application brought before it by the private citizen Theodore Kofi Atta Court, essentially challenging the process to possibly remove the suspended Chief Justice Gertrude Torkonoo. From what we do know and what Lord has just told us, the application was deemed unmeritorious and subsequently dismissed. And in fact, it is the second on the same matter to have been dismissed by the Supreme Court panel on the same day. So how is all of this really, from where you sit, playing out for you? Could there have been any other outcome apart from this, especially because this is not the first time a suit of this nature has been filed at the Supreme Court and dismissed prior to today?
Okay, in terms of any other outcome, easily we say, yes, they could have won. They lost, but they could have won because that's the other one. That's answering the question legally. But maybe practically, we can say that the going out of the first one was an indication to them that that's Kofi Atta, right? Was an indication to him that he had a very tall order to clear. It was quite a tall order, right? But let's also, it's all right. I mean, the most important thing is that it's been resolved. If it hadn't been resolved and it was left hanging for months, then that's when it would have hurt our democracy, because any pending suit in this matter serves as a cloud hanging around the case. And so you don't want any hanging clouds. So let's look at it from that governance perspective. Because once you have somebody challenging it, when history is written, it will be stated that, oh, for 3 months or 4 months, there was this case challenging the whole process and all that. So then that reduces the legitimacy and the apparent and apparently reduces the integrity of the process, because call the lawsuit a protest. It's a protest, meaning that some citizens were protesting. Yes, there have been other forms of protest, but I know when you make it into court, paying lawyers, etc., it's usually weightier. But okay, I'm not just talking because we say talk is cheap, but you also walk your talk by paying lawyers and all that. So if you look at the legal expense of going to court, then it makes a legal protest somewhat weightier. So once it's been cleared quickly, that is good for the integrity of the process. So for me, there is a win-win for all sides. But the citizen is allowed to ventilate his claim, and that also the justices have cleared the injunction so that it reduces the hanging clouds. But, throwing out the injunction doesn't mean the whole case is gone. So there's a substantive suit, right? So that will be gone into.
Yes.
An injunction is an application, but it is hinged or it is based on a case proper. So meaning that there's a substantive suit, or is the report that they've dismissed both? I don't think so.
See, but you see, here's where the other issue also comes up, to the extent that if you look at the reliefs that Atta was seeking, 5 major reliefs from the Supreme Court right now. Counsel, we've got some exclusive detail coming through right now. Some information from our sources within the Supreme Court, and that her ladyship, the Chief Justice, the suspended Chief Justice, has herself dragged the Attorney General, Justice Gabriel Scott Puaman, Justice Samuel Kwame Adibo Esiedu, Daniel Yao Domelevo, Major Flora Dalugo, and Professor James Sefa Jisa, the 5-member committee members, and also the acting CJ, all to court as we speak. There is a suit which we have just received a copy of right now, and these are the reliefs that she's seeking: an order restraining the committee set up by the president to inquire into the 3 petitions against the plaintiff, composed of the 2nd, 3rd, 4th, and 5th, and 6th defendants, from proceeding with that inquiry, the execution of the terms of reference of the committee, or taking any action in connection with the purported determination of a prima facie case made against the plaintiff until the hearing and final determination of the instant action. That is the breaking news coming through right now here on Hot Edition on 3FM 92.7. Council and Dennis Pabere is going to be joining me right now, because we're getting to some more details of this exclusive information we've got right now. So that is the information we're getting right now, that the suspended Chief Justice, her leadership, Justice Gertrude Torkonoo, has dragged the Attorney General, Justice Gabriel Scott Puaman, Justice Samuel Kwame Adibo Esiedu, Daniel Yao Demelevo, Major Flora Dalugo, Professor James Sefa Jisa, to the Supreme Court. She's seeking a number of reliefs. The first I've just read. The second is an order restraining the 2nd and 3rd defendants, respondents, from presiding over or participating in proceedings of the committee appointed by the president to inquire into the 3 purported petitions presented for the removal of the plaintiff as Chief Justice of the Republic until the hearing and final determination of the instant action. That's not all, Council. She's also seeking the 3rd relief, an order suspending the operation of the warrant for suspension of the Chief Justice purportedly issued by the President under Article 146(10) of the Constitution 1992 until the hearing and final determination of the instant action. Any further orders to this Honorable Court may seem moot. In fact, that's the 4th relief that she's seeking as well. And this was filed today, the 21st of May, at 3 p.m., just some 2 hours ago. So that's the information coming through right now from our sources within the Supreme Court. Counsel.
Okay, so what I should say is that that's another citizen trying to, those citizen and also Chief Justice, or suspended Chief Justice, trying to ventilate, her claims. It's fine, because it's within her right under the Constitution. Any person who feels aggrieved may approach the court to ventilate their claims. We can't take it from her, right? So it can legally, it can go on. The only thing is that from day one, I've been saying that, and I still believe so, that, look, because this whole process, is kind of weighing on the integrity of the whole justice system, it would have been better if the suspended Chief Justice had resigned. The way we are fighting over this, it's quite messy. Yeah, it doesn't look good. It doesn't look good. You see, the Bible says, is it Romans? I've forgotten the exact scripture. It says that, yes, it's not every right that you have that you must exercise. So, yes, all things may be done, but it's not everything you do that helps the cause. So sometimes you look at the generality of the interest, you look at the interests of the society, and then you say, okay, I'll let go. Because this fight, the more we fight, it's just going to hurt the whole system. It's already hurting us. And also, it's not only the system that it will hurt, but more people too will throw dirt at her and the rest. I'm sure you've seen the other things that have been put out there in the media. I don't want to mention. And you see, Mustafa Gbandi had once mentioned that other petitions have been filed against the suspended Chief Justice. So that is where we are all going to suffer a lot, because as long as these things go on, more people will then dig and bring in more issues, either in the form of lawsuits or newspaper publications, etc. Those don't bode well for the society. So sometimes you look at the larger interests of the society, then you let go. Because yes, as for fighting, the court is there. Yes, the court is there. It's within her right.
Yes, you're of the view that she should have resigned. I mean, but she's also exercising that right of not resigning and pursuing her rights, as you have acknowledged that it is within her right as well to institute such actions as we have seen right now, is it not?
Yes, so that's why I said yes. So you may be right on paper, but practically you cause a lot more harm, because it's a long drawn fight, right? They've not finished the hearings, and then there is more. So the current suit, it's also now going to cause a lot of commentary. Oh, no. It doesn't help our society. No, it doesn't help, because, people are going to dig in their heels. They are going to dig in their heels, so there will be accusations, counter-accusations, recriminations, counter-recriminations, etc. And so where are we going to stop? Like, see, if Justice Torkonoo had just resigned, it would have helped to heal matters quickly. Yes, help to heal matters quickly. But with this new lawsuit, so they're going to be going to court again, and it's messy. I don't think we should go through this as a society.
So it's a matter of, as you've underscored, her right, and then also a matter of balance. I mean, so, Counsel, from where you sit, what would have been the consequence of she taking that decision to resign, as against she also staying on, pursuing this matter well within her right, and then having the outcome after the process has been exhausted?
Yeah, so if she had resigned, it would have helped the system to heal quickly. You see, it would have reduced also it's a form of attack on the system, because you see, when we say attack, it may not even be direct, but once the whole system is being questioned, the whole system is being talked about, then we suffer a certain reduction in integrity. You see, sometimes it's not only directly, the person doesn't have to say, oh, the justice system is bad. No. But the fact that week in, week out, it's about the Chief Justice. It's about the Chief Justice. Something has been done right. Something has not been done right. So even the conflict alone, you see, the dispute alone and the discussions create that apparent lack of fairness, that weakness in the system. It reduces the integrity apparently, because everybody will like, oh, if the system was that good, why would there be such a big dispute surrounding the Chief Justice, etc.? So you look at it from that perspective and you see that, oh no, listen, let me resign so that we can preserve the system. You see, but now with the challenge, people will have opportunity to comment, lay people, etc. You know, the more people have an opportunity to comment, etc., then the more there's a myth of integrity around the justice system, the more it is broken. Because it will be like, if you guys were conducting yourselves well, would we have been allowed to come in here? Or would this matter have arisen for us to come and comment? So the moment you give an opportunity for citizens to keep commenting and comment, yes, it strengthens the society on the other hand in terms of freedom of expression. But where we lose is that then the justice system is being evaluated, berated, and cast down every day. That is not good for the system. Yes. we support freedom of speech, etc., but there are limits. It's not the justice system in this manner that we want to use. Yes, we would like to hear citizens complain that the court systems are outdated, the laws are outdated, our justice system is not modern enough. Yes, we are not operating a modern justice system. Yes, those ones fine, but not the conduct of judges. You see, because in our society, a lot of people look up to judges, so, and then lawyers. So we expect that, like the way we say, Caesar's wives, that thing that live beyond reproach, they reproach. Caesar's wife's test. So the conduct, the standard that we use is our conduct should be said that nobody should suspect us. And that's how the ordinary man expects of the justice system to operate. It should operate in such a way that people do not have suspicions. But the moment people, actors in the justice system, have done things that have raised suspicions, then they are losing marks. That's the whole thing. Now it means that the justice system, the conduct of judges, etc., has become the central point of discussion for months. Yes, by the time we are done, it will make the society stronger because, yes, there will be more freedom of expression, that we took on the justice system, we had everything to say, blah, blah, blah. But integrity-wise, would have lost. So it's a balancing act. Since there are other areas, aspects of the justice system that we can debate about and not lose as much marks, I prefer we do that. And that's why I said, if the debate were about our outmoded court system, our outmoded, many laws which are outmoded, all right, inefficiencies in the system, yes, that one very good for discussion, and then, yeah, that helps us a lot more. But now where we are discussing is the conduct of judges.
Absolutely.
And don't forget, we just came out of the Anas debacle, where, they could say, give me two.
But is that not also rather better? That, we discuss the conduct of judges, the conduct that does not, as it were, fit the proper definition of how judges should conduct themselves, well discussed, condemned, as you believe, named and shamed, to correct the system, instead of rather not talking about it because, as you say, you want to protect the integrity of the judicial system. That will certainly not be good.
Yes. So this is not good because, as I said, the judges are the arbiters. So if we keep discussing and in the process denigrate them, confidence in the justice system is thereby reduced drastically, because, as I said, we've barely recovered from the Anas expose. We've barely recovered. It took, I remember, several chief justices even going to bring the International Bar Association to come and sign memorandum with the judicial service that they are fighting corruption, etc. Yes, I remember Chief Justice Akufo. Yeah, her time they had to bring the IBA. IBA came and signed a memorandum with judicial service. Chief Justice Akufo was in charge. Blah blah blah. We are fighting corruption and all that. So we barely recovered. We've not finished recovering. Nowadays, at the example, give me two judges has gone down. But those days you hear, give me two judges, mean give me two pieces of goat meat. Because in the Anas expose, some judges were seen taking goats, or they were seen to have been bribed with goats, etc. So, as I said, we are opening up raw wounds. We are opening up wounds. We should let sleeping dogs lie. But this particular case is waking up so many sleeping dogs. So in the process, we are all subject to attack. All of us, including lawyers. Yes, because when they are questioning judges, lawyers, you are also questioned indirectly, and some even directly.
Counsel, I do appreciate your time and your initial thoughts on this matter. As I indicated, this is breaking news coming through, and so it's in fact unfolding thick and fast. And there's going to be a bit more reactions and details as the minutes go by. But thank you so much for your thoughts on this.
You're welcome.
Martin Kpebo is private legal practitioner, sharing his thoughts initially on this. So if you're just joining us, this is some breaking news that we've been digesting here. So this is some news. If you're just joining us, coming through, the suspended Chief Justice Gertrude Torkonoo has taken legal action against the Attorney General and the 5 members of the committee hearing her petition. This is a significant legal development. Dennis Pabere Wadame Subme in studio. What are the reliefs that the Chief Justice is seeking?
Well, Alfred, this appears not to have an ending anytime soon. Is the Chief Justice herself now as the plaintiff in this particular matter, taking it against the Attorney General and the members of the committee that have been put together by the President to inquire into petitions seeking her removal. Now she's seeking reliefs as follows. 1, she wants an order restraining the committee set up by the President to inquire into the 3 petitions against her, composed of, and it lists the members of the committee, which include Justice Gabriel Scott Poamang, Justice Samuel Kwame Esiedu, Daniel Demolevu, Major Flora Dalugu, Professor James Sefa Jifa. So those are the members of the committee put together by the President to inquire into these petitions that we understand are 3 in number, for which she is currently undergoing that particular process. So she says that she wants an order which will restrain them from proceeding with an inquiry, the execution of the terms of reference of the committee, or taking any action in connection with the purported determination of a prima facie case made against her until the hearing and the final determination of the instant matter. The instant matter would suppose that there is a substantive suit for which this injunction has been mounted on. She also wants an order restraining the 2nd and 3rd defendants, and 2nd and 3rd defendants here refer to the chairman of this committee, that's Justice Gabriel Scott Poamang, and then Justice Samuel Esiedu. Well, on the face of the application that we have, it does not state why, except to say that an order to restrain them from presiding over or participating in the proceedings of the committee appointed by the President to inquire into 3 petitions purportedly presented for the removal of the plaintiff as Chief Justice of the Republic until the hearing and the final determination of the instant action. She also wants an order suspending the operation of the warrant for suspension of the Chief Justice purportedly issued by the President under Article 14610 of the 1992 Constitution until the hearing and final determination of the instant action. And finally, as you would have it in such processes, any further orders that the Honorable Court may deem fit. And Alfred, it's important to put on record that earlier today, the Supreme Court had reason to look into some interlocutory injunction applications, 2 of them, and dismissed 2 of them by majority decision 4-1. The reason this is important is because the first one, which was brought by a civil society organization, Center for Citizenship, Constitutional and Electoral Systems, in that particular matter, the Chief Justice was part of the application as a 2nd defendant. So the civil society group is the one with the case. They filed the injunction application as the applicants in that matter. The chairman of the committee that is looking into the petitions, Attorney General was the first defendant respondent, the Chief Justice 2nd, and then the chairman being the 3rd. What happened in court today was the fact that when the petitioners and applicants made their case or moved their motion, it appeared that the 2nd respondent, who is the Chief Justice, had a lawyer to herself, and her arguments were in line with that of the plaintiff. So this civil society group, which was seeking to stop the process, actually had their arguments very much like that of the Chief Justice. And of course, the lawyer indicated that yes, they agree with the views of the plaintiff applicants, except with a few modifications here and there.
Right.
It became so obvious that they were in the same line, so much so that the Attorney General, on a few occasions, said he almost referred to them as the 2nd plaintiff. That is to say that the position, even though they appear as defendants respondents, the position that they took almost appeared as though they were defendants. And let me illustrate to you how that has now reflected in what we are seeing. So one of the key arguments that was made by the Chief Justice in that particular suit was to the effect that they never received. In fact, the argument is that that a prima facie case has not been determined, for which reason a committee could have been constituted to even look into the matter and a subsequent suspension of the Chief Justice. Their argument simply was that as far as they are concerned, there is only a communication in the public which communicates a purported determination of a prima facie, and that in their view, one does not even exist. When you read the wording of this particular application, you would also find traces of things like purported petitions. That is even to say that this again will take us to a point where there will be a question of whether the existence of the petitions actually exist or they do not exist. Even though that came up when Justice Yoni Kolendi was having a conversation with lawyer when he made the assertion that for them they think that there was no determination of a prima facie case. Then Yoni Kolendi asked, okay, for all the processes that have been referred to in the suit, for instance, the petitions, we do not see the petitions. It was only a communication from the presidency that announced the petitions. So are they also saying that such petitions are purported petitions? That was conveniently avoided. There was also another question of the formation of the committee, because it was a statement from the presidency that announced that committee. So Justice Yoni Kolinde asked, are we also saying that because a statement from the presidency announced what you call a purported committee, does that mean the committee does not exist? So this is just to say that these are matters that were partly dealt with in this particular case, except to say, even though they've not given their full ruling, these are matters that were briefly touched. And more importantly, Alfred, when the second suit was being heard, the first intervention by the bench was by the presiding judge, that is the acting Chief Justice, Justice Bafuboni. When they mentioned that they were seeking an order for the suspension of the warrants, the the acting Chief Justice drew the lawyer's attention to the fact that by a few days ago, we decided on a case with a similar relief.
I see.
Then the lawyer said, yes, but our arguments are different. So they allowed him to proceed. Just when he was about proceeding, Justice Amadou Tanko came in to make an intervention and to say that one would have thought that when this same court decided on similar matters with similar reliefs weeks ago, and even one before you came in, but our ruling and reasonings are not yet out. But mind you, Vincent's case, the reasoning is supposed to be released today. So even indicated by close of day, at least you have the reasoning of the court in respect of that. So one would have thought that coming on similar ground, seeking similar reliefs, one would have waited for you to see what is in there, and if it does not address your concerns,
then you go ahead to file.
But of course, that was just an advice. He gave the lawyer the option
to wait.
So the lawyer proceeded. I mean, for others who were watching, perhaps that was a cue for the lawyer to choose whether to want to proceed with it or to withdraw the application. But it was signal of how the outcome was going to be. But eventually that too was dismissed by the same 4-1 with Justice Yao Asaridako dissenting. So this is just to put the matters into perspective.
And it's a very important perspective you bring to the matters. And you are in court today, so you have a first-hand view of how things played out. And this is where I bring in a private legal practitioner, the former director of the Ghana School of Law, Mr. Kweku Annan, and he's been monitoring how events have been unfolding since this entire process to indeed have the 5-member committee start the hearing of the petitions against the Chief Justice started. Mr. Sassari, good evening. Thank you for joining us.
Thank you, my brother.
There have been two significant developments today. As we know it, the Supreme Court earlier today, and you heard my colleague Dennis Boberi Wadam Esquire the Supreme Court dismissed another suit against the Chief Justice removal process on the basis that it was unmeritorious. And then we are just getting information now that the suspended Chief Justice Gertrude Torkonoo has taken legal action against the Attorney General and the members of the 5-member committee that has been set up to hear the petitions against her, asking for her removal. In this significant development, the suspended Chief Justice, her Ladyship Torkonoo, has personally initiated these legal proceedings by filing a writ, and in the writ, she outlines her objections to the continued actions of this committee that is currently probing matters related to her suspension. As part of the reliefs being sought, the Chief Justice is urging the court to halt the scheduled sitting of the said committee, which is expected to convene tomorrow morning. In addition to the writ, the Chief Justice is also filed a formal application for an injunction. This injunction is seeking to restrain the committee from proceeding with its activities until a determination is made on the substantive issues raised in her suit. I mean, how does all of this strike you because of how this matter has proceeded till now?
Okay, thank you very much. It's interesting. This is a twist, to the saga that began to unfold as from the 17th day of October 2024. And if you recall, I did indicate in one of my contributions in your program that what the Chief Justice did on the 18th of October, sparked off, what I termed as constitutional lawlessness, and that is, unfolding in stages. Now, if indeed the Chief Justice has slapped a writ on the judicial process, there are two things I can say. One, the writ can make or mar the relationship between the Chief Justice and the executive, i.e. the President. Two, the Chief Justice has shot herself wrongly in the foot by commencing the instant proceeding. It's not good for her. It's not good for the country. It's not good for democracy. Now, I don't want to go into the merits or otherwise or the rate, but this is a process that the Chief Justice herself ought to appreciate, that it is embedded in the Constitution of 1992 of the Republic of Ghana, that the CJ removal process is chronological. There's a chronology. It is a staged process. It's staggered from A to Z. And therefore, she being the head of the judiciary should rather assist in upholding the rule of law, which is the cornerstone of the administration of justice. The Constitution says that from time to time, the citizens may participate in the administration of justice. And one of it is to petition for the removal of justices of the Superior Court, including the Chief Justice. Now, if the Chief Justice is the chief custodian of the Constitution, and the Chief Justice herself is attempting to halt the forward march of the constitutional process, then the signal to the whole nation is that she cannot work with the executive, even if the petitions fail. I have cautioned and suggested that she should take a back seat. Government should take a back seat. They should allow people who are less emotionally touched as far as this matter is concerned, so that, it will bring it to an end. It may either fail or it may succeed. By bringing this action, she has closed the door. Now, before, the door had been slammed, but the key was left hanging absent, so that one day she could go and take the key, unlock, and then enter. But what she has done now, even if the petitions fail, I don't think that she can ever work with the executive again. It's a wrong move.
Yes.
Now, as far as the injunction is concerned, I can predict that it's doomed to failure, because such an injunction maybe the Chief Justice may be required to address the court on specific points of law and fact on the basis of the papers she has filed. What is she going to allege? It is the same response, to the president based on the petitions the president forwarded to her. Therefore, what he's trying to do is, yes, I have responded, but no, I will not allow you to go into that. The wrong signal to the nation is that she has something to hide. When to all intents and purposes, she may have a good case, but it's like she's drowning and she's trying to clutch onto any straw that may come her way. That's not how to litigate such sensational and sensitive matters of national importance and interest. I think that whoever advised her to do that, has still advised her. I wouldn't advise her to do that, and it's a wrong move.
But it's well within her right to do what she has just done. I mean, you described it as a wrong move. She wants to pursue this matter in the court.
She's the chief protagonist, and therefore, she must not be drawn into what people who are less knowledgeable about the law will do. She is the chief priest or priestess of the judiciary. That's how come she's the Chief Justice, the head of the judiciary. She's trying to stop a constitutional process. That in itself, is a base to impeach her. That in itself, because she's seeking, to act contrary to the dictates of the Constitution. I mean, it's a wrong move. It's a wrong tactical move.
No, sorry. Appreciate your time on this, and we'll see how this will play out, especially because Dennis, my colleague, references that some of the relief she's seeking are contained in a previous injunction filed by Vincent Assefuah, of which the full ruling, details of the ruling, will be out by close of day today. Would you also go on that same path that one of the justices was seeking to sort of advise the lawyers of the Chief Justice that to wait for the full ruling of the previous injunction that was thrown out on this similar relief to be out today to guide them on what next step to take instead of filing the injunction earlier today?
Well, it's a constitutional right to act, within the dictates of her own judicial conscience, and person. I mean, she may decide to go, the right way or the wrong way. But interestingly, if I heard you, right, you did mention the fact that she's seeking, she's seeking the removal of two justices, on the panel. That's Puama and Echidu. That's another dimension. But whatever it is, it's a right. I'm saying that, just as a judge, they may decide to, go right or wrong. So a litigant may also choose, to go right or wrong. But the head of the judiciary, being the architect of the, judicial architecture, must be the last person, to sue the president. I mean, if you sue the chief justice, the attorney general, you have sued the president. The fact is that the president may not be sued, within the period that the president, is the chief executive of the state, and therefore the person you can sue is the attorney general. If you want to sue the state, you are suing the executive. you are suing the judiciary, you are suing the legislature, and it is the Attorney General, who will have, to defend, howsoever she chooses and whatever way she chooses, to run this saga. It is the Attorney General she must sue. Now, if she wins, let us, say that for purposes of argument, she wins. How is she going to, repair the harm as far as the relationship of the office of the Chief Justice and the office of the President is concerned? How is she going to repair that harm? It's irreparable. And this is why I'm saying that whoever advised her, to comment this action has done more harm to her than good.
I do appreciate your thoughts. Very, very important issues to raise. Sorry. Thank you so much, as always, for coming through for us. Appreciate you. That's the former director of the Ghana School of Law, Kweku Annan. They're sharing their thoughts with us on this latest development. Dennis Poberi with Esquire still with us in the studio. A number of you have been sharing your thoughts on this. So many of your messages, we'll get into them right now. Christabel, what are our viewers and listeners saying?
Yes, Alfred. Our listeners and viewers have a lot of interesting things to say. And Mahamadu Bawumia is saying that the suspended CJ might have the right to sue, but the fact that the MPP is fighting for her makes me think she was brought in to do their bidding. That's why they are struggling and demonstrating for her reinstatement. Now, I understand why she was appointed. And politicians often use people for their own gain, and it seems like she's just a pawn for them. She needs to go. He continues to say that there's a Dabani saying, you can't slaughter a chicken without it struggling. The suspended CJ is fighting back, but it's too late. Unfortunately, she let politics influence her decisions. Hopefully, the next person in her position will do better and remain impartial. Well, on social media platform, we have Sky Bear saying that the same disregard for rule of law is being applied to you. No matter how much you shout or resist, the law is the law. And on YouTube, Our Rights is also saying, so where does this stop? Let's please stop this circus. So if today 1,000 individuals wake up in foul suits, the Supreme Court should tolerate this.
Yo, before we and somewhere about beto, Yaponoso, Mekause, so we can subscribe to channel here, but more than I say, over subscribe. Now, I like video, don't give us a thumbs up. Now, share my wolf for froso. Now, when you be here now, and somewhere also, Ghana memoir. Also, bet me actually wondering if I and some way now, comment box in Mobeti Mekabim. In my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.